From the comments on episodes of this podcast, it is very clear that child support is the part of divorce and family law that many people hate the most. Since in Canada monthly child support is based entirely on the parent's income, it might seem logical that a parent can reduce his or her child support obligation by reducing his or her income. That may seem like a smart idea, but it's not. In fact, even people who have legitimate losses of income can find it difficult to reduce their support obligations. And yes, the same principles apply to spousal support. In this episode of the Ontario Family Law Podcast, I will answer subscribers' question and we will cover why intentionally reducing income will not lower support, and how those rules can even affect people who have lost their job or had other income losses. I'm Schuman, a certified specialist in family law in Ontario, and I've been recognized for my concerns over children's law issues, difficult parenting cases, and complex financial matters. I'm also a mediator, arbitrator, and collaborative lawyer. I have a best-selling book, The Guide to the Basics of Ontario Family Law, which is available on the iBookstore, Amazon, Kobo, and in fine bookstores. If this episode covers topics that are important to you, then you will likely find that book very helpful. Child support in Canada is based on the payer's income, and as I covered in episode 89, child support keeps going up without a cap as the payer's income goes up. Where the parents share the parenting of the kids close to equally, then technically they are both child support payers, and each payer's income determines how much each parent pays. For spousal support, the income of each spouse is important. Support is based on income. So, as I noted, some people who want to reduce their support decide to reduce their income. Let's take a look at the logic there, especially for child support. Child support for one child is about 8.5% of the payer's income. So the payer would have to decrease his or her income by more than 10 times the amount that he or she wants to reduce support. Put another way, to reduce child support by $100 a year, the payer has to reduce his or her income by over $1,100. The payer loses 10 times more money than he or she saves in support. For two children, the percentage is around 14% of total income. So then the support payer has to reduce his or her income by over 8 times what child support is reduced by. The payer loses more than $8 for every dollar he or she will save in support. It's almost 16% for 3 children, but still the payer has to reduce his or her income by many more times than the child support savings. The child support payer never comes out ahead by reducing income to reduce support. In my episodes on how to pay less child support, I went over some better and worse strategies to pay less support. So check out that episode. And if you're finding my episodes helpful, be sure to subscribe, push the like button, and hit the notification bell to keep up to date. And keep more episodes coming your way and help other people who need this information find these episodes. Also, remember that my book goes over all aspects of child support and other family law topics, as well as giving a detailed description of the paths you have to follow after separation. The ebook is under $10, so head to Amazon or the iBookstore to get it right away. Reducing income to reduce child support is a bad financial plan. It might be less bad if spousal support is in play too, but in many cases that does not work out either. Still, so many people have tried the strategy that child support guidelines specifically address the situation. And judges are vigilant and suspicious of all declines in income. And just to clarify, the spousal support guidelines use the same income calculation rules as the child support guidelines. Section 19 of the child support guidelines lists a number of situations where a judge must increase a parent's income for child support purposes over the amount that the support payer reports on his or her tax return. Again, there's another episode of this, number 76, that explains all the situations in which a judge would order that a person pay support based on income that is higher than he or she reports for taxes. And as you may have guessed, my book covers the topic in even more detail. But for now, let's focus on section 19 sub 1 sub a, which allows a judge to increase the payer's income and thus his or her child support on the basis that the parent is intentionally unemployed or underemployed. The child support guidelines require that each parent make as much as he or she is capable of working to calculate support. And where a parent deliberately does not do that, a judge or arbitrator can increase the income on which support is based, and thus increase child support to a level that reflects what the payer should be making. A self-induced reduction of income will not result in a reduction of support payments. The courts have said that there is a duty on the part of support-paying parents to seek out reasonable employment opportunities to meet the needs of their children. What would be reasonable employment opportunities for a parent? They are ones that reflect that parent's background, education, training, and experience. Judges will look at the salaries for jobs for which the parent appears qualified when determining whether a parent's income is appropriate, or whether that parent should have to pay more. Evidence that a parent has been turned down for jobs helps that parent show that such jobs are unrealistic. But the parent does have to produce the job applications and advise how far the applications progressed. Sometimes because their education or training is out of date, or the parent has too many childcare responsibilities, or the parents develop physical or mental health struggles, a type of job that would have been suitable before is no longer suitable. But again, the parent is going to have to provide evidence, both of those challenges to employment and any job rejections due to those factors. Without compelling evidence that the situation has actually changed dramatically, judges are very likely to make a parent pay child support on what that parent used to make. A parent whose income fell from $100,000 before separation to $60,000 after separation could find that he or she pays support based on an income of $100,000, and that can really sting. It has to be really clear that the parent did not cause or contribute to the reduction of income, and that the parent is completely unable to continue to make the original higher level of income. Judges are used to separate parents and spouses playing games, either to deliberately and illegally screw over an ex, or to avoid a legal obligation to an ex-partner. I went over 10 strategies that fail in family court in episode 83. Judges are very skeptical of parents whose income decreases when support is payable. They will not believe that support should go down unless there is good objective proof that the payer was fired, or there was another reason for that drop in income that had nothing to do with the support payer. If it looks like the support payer got him or herself deliberately fired, a judge will refuse to reduce that now unemployed parent support obligation. If the support payer claims that his or her income has gone down because of a medical condition, mental health issues, or disability, the judge needs to see medical records to support that claim. That means the ex gets to see those medical records too. But if there is a medical reason for the decrease in income, the support payer has to prove that to the ex and to the judge. Sometimes people lose their job because the industry has changed. Many types of jobs have disappeared completely in the last several years. When was the last time anyone needed someone who could set a printing press? Voiceover artists have been largely replaced by AI. How many people use travel agents now? For others, the technology or the industry has changed. Advertising now looks very little like it did 20 years ago. All these factors mean that many people have lost their jobs. But even though many of these may seem obvious, they never seem obvious to a former spouse or partner who is being asked to accept a reduction in support. And as judges are skeptical, the parent with the now reduced income will need to prove that there has been a change in the industry and prove that he or she needs to retrain to stay in the industry, or that he or she needs to start over in a new industry. That can involve getting a vocational assessment or a report from another objective expert to explain why that person just cannot make what he or she used to. Obviously, getting an extra report or evidence costs money. In episode 51, I went over some strategies to keep costs down, or even to get your ex to pay your costs. But a consideration is whether the cost of proving the need to change support will cost more than the amount of the reduction in support. Although sometimes it can also be expensive to prove that a former partner should be making more than he or she claims. I have referenced several other episodes in this episode. For more information about other family law topics, please subscribe, like this episode, and hit the notification bell. You may also want to pick up a copy of my book. In addition, you can get a lot more Ontario family law information on www.schumanlaw.ca. And on my social media feeds, check out my Facebook page, follow me on Twitter and Mastodon at @SchumanFamLaw, and follow me on LinkedIn, Blue Sky, and Threads. You can email me at john@schumanlaw.ca or call my office at 647-342-6775. The cost of just changing support can be something to consider too. By far the least expensive way to change support is to use the government's online child support recalculation service. But that service bases support on what is in the parent's tax returns. It cannot recalculate support based on what a partner should be making. Rarely does a former spouse agree that he or she has deliberately reduced his or her income and should pay child support or spousal support based on more than he or she makes. That makes it hard, although maybe not impossible, to sort out a deliberate reduction of income through negotiation or mediation. To get that kind of adjustment, you need to go to court or arbitration. I describe the options about that in episode 66. But note that court and arbitration both cost money. Unless you are able to recover your legal fees from your ex because he or she is acting unreasonably, the cost of changing child support is often more than the amount of the change. You may need to speak to a good family lawyer about the options and what will benefit you the most. The amount of money in play is often much more when spousal support is an issue. Spousal support is also dependent on the incomes of both parties, which can make intentional unemployment or intentional underemployment an issue, and perhaps one with greater impact. In addition to the incomes of the parties, spousal support is affected by the length of time the parties live together, the number of children, and how much each spouse sacrificed financially. Those factors can result in a support payer paying half of his or her after-tax income or more to an ex. That gives any reduction in income a much higher impact, as long as it is a proven legitimate reduction of income. The same factors that can result in a parent paying child support on a higher income than he or she earns can result in a spouse paying spousal support on more than income than he or she earns. If a spouse is paying half of his or her net income to an ex, paying support on more than that support payer earns can have devastating financial consequences. The same considerations I mentioned in this video apply to spousal support, but become more important and may be more hotly contested. A parent or spouse cannot deliberately reduce his or her income to pay less support. Support is based not on what a parent or spouse actually earns, but what a parent or spouse is capable of earning. Proving that a decrease in income is legitimate or that a former partner is not earning enough can be burdensome. For child support, deliberately reducing support or proving that you did not deliberately reduce support may not be worth it. If spousal support is in play, then it may make sense to fight. Keep in mind that judges are always skeptical of reductions in income and the claims of separated spouses. To get support right or to know whether you should bother, it is important to get the advice of a good family lawyer. Please feel free to contact me at john@schumanlaw.ca or the phone number in the description. And of course, to get a lot more family law information, including information about child support, spousal support, other financial matters related to separation and divorce, or parenting considerations, and to understand how family court works, including explanation of all the steps and the alternatives to court, get a copy of my book, The Guide to the Basics of Ontario Family Law. You can access it immediately on the iBook store, on Amazon for the Kindle version, or you can order it from Amazon and have it delivered directly to your doorstep. Check me out on social media, and please subscribe to my YouTube channel and hit the notification bell to keep up to date. You can get the audio versions of the Ontario Family Law podcast on all major podcast services, including Apple Podcasts, Spotify, Google Podcasts, Amazon Music, and many more. They are also available at www.schumanlaw.ca. Just look for podcasts in the drop-down menu. Thanks for participating in this podcast. We will get together again soon.